The history of lending discrimination. Systemic racism still bolsters the racial wealth gap. Laws today protect borrowers from discriminatory lending practices, but that wasn't always the case. For decades, U.S. banks denied mortgage to black families and those belonging to other racial and ethnic minority groups who live in certain areas redlined by a federal government agency called the Homeowners Loan Corp. Lending discrimination occurs when lenders base credit decision on factors other than the applicant's creditworthiness. Denying financial services to residents of certain neighborhoods due to race or ethnicity is called redlining. The discriminatory practice of redlining made it impossible for many members of racial and ethnic minority groups to qualify for mortgage loan. Redlining is one factor behind the racial wealth gap that persists in the United States today. Laws today forbid discrimination based on race, color, religion, sex, national origin, handicap, familial status, age, and whether you receive public assistance income. What is lending discrimination? Lending discrimination happens when lenders base credit decision on factors other than the borrower's creditworthiness, including any of the protected classes defined under federal law. Today, three federal laws offer protection against lending discrimination: the Fair Housing Act, the Equal Credit Opportunity Act, the Community Reinvestment Act. Fair Housing Act of 1967. In 1948, the U.S. Supreme Court deemed racially restrictive deed covenant unenforceably. 20 years later, the Fair Housing Act was enacted. The law protects people from discrimination when they rent or buy a home, get a mortgage, seek housing assistance, or engage in other housing-related activities. It forbids discrimination based on race, color, national origin, religion, sex, familial status, or disability during any part of a residential real estate transaction. Equal Credit Opportunity Act of 1974. Discriminatory lending and housing practices continued despite the Fair Housing Act, and civil rights groups advocated for more legislation. In 1974, Congress passed the Equal Credit Opportunity Act. According to the Federal Trade Commission, the ACOA make it illegal for creditor to discriminate based on race, color, religion, national origin, sex, marital status, age, or because all of a person's income comes from public assistance. Creditors can ask for some of this information, but they cannot use it to deny your credit or establish the term of your credit. For example, lender can ask if you receive alimony or child support, but only if you need the income to qualify for the loan. Community Reinvestment Act of 1977. Even with the FHA and ECOA, redlining continued in low to moderate income neighborhoods. In its discussion of this period, the website Federal Reserve History notes there is some evidence that overt discrimination in mortgage lending persisted. A few things happened as a result. Illinois became the first state to pass a law prohibiting redlining and required banks to disclose their lending practice. Congress passed the Home Mortgage Disclosure Act, which required banks to disclose the location of financed properties and borrowers' race and gender. Then President Jimmy Carter signed into law the Community Reinvestment Act. The CRA was enacted to prevent redlining and to encourage bank and saving associations to help meet the credit need of all segments of their communities, including LMI neighborhood. The law directed federal regulatory agencies to assess the institution record of meeting the credit needs of its entire community, including low and moderate income neighborhoods, and take such record into account in its evaluation of an application for a deposit facility by such institution. What is redlining? Before laws expressly prohibited discrimination in lending, a practice known as redlining prevented certain populations from accessing credit. Redlining is the discriminatory practices of denying financial services to residents of certain neighborhoods due to race or ethnicity. Sociologist John McKnight coined the term in the 1960s to describe maps that marked racial and ethnic minority neighborhoods in red, labeling them hazardous to lenders. Thank you.